This is the time set for a status conference and omnibus hearing in the matter of iCap Enterprises, Inc., case number 23-01243. On behalf of the debtors, we have Julian Garuli.
Good afternoon, Your Honor.
And Khaled Tarazi.
Good afternoon, Your Honor.
On behalf of the creditors committee, we have Jay Cornford.
Good afternoon, Your Honor.
Assistant U.S. Trustee Gary Dyer.
Good afternoon, Your Honor.
Darren Cratley on behalf of Redmond Funding Group, LLC.
Good afternoon, Your Honor.
Guy McCarroll on behalf of Serene Investments Management.
Good afternoon, Your Honor.
And Zachary Cooper on behalf of Socotra REIT, LLC, We Alliance Secured Income Fund, LLC, and Jason Yelowitz in his capacity as trustee.
Good afternoon, Your Honor.
Is there anyone else on this call that I did not identify?
Yes, this is Lacey Curtis on behalf of Oak Hill Construction.
Thank you. And if just one last moment to make sure that everyone, unless you are going to approach the court, to please leave your phone on mute. This hearing is being recorded. Please proceed.
Good afternoon, everyone. I hope you're doing well today. So we have one motion before the court and then our general periodic status conference. I reviewed the status conference report, which has a couple of issues to touch on today. But before we get to that, why don't we talk about the debtors have a pending motion for court approval of the sale free and clear of two different properties. There were no objections filed to that motion. The status conference report indicated that there were informal discussions with the lien holders on certain of the properties, which I imagine culminated in, I believe it's paragraph 14 of the revised proposed form of order that was filed earlier this morning, which paragraph provides for the agreed segregation of certain of the proceeds of the property sales. If that didn't resolve the objections, I'm sure I'll hear from folks today. The court's reviewed the form of order, has a couple of minor tweaks that we could probably just make on our end. One of them I'll mention on the record, just so it's on the record, but otherwise I'm prepared to hear from anyone who would like to be heard today. Mr. Gwilly, Mr. Gwilly or Mr. Tarazi, why don't I start with whichever one of you is covering this motion this afternoon.
Thank you, Your Honor. Khaled Tarazi of Buckhalter on behalf of the debtors. And as usual, Your Honor, our status report tends to steal our own thunder, so not much to add at all to the comments that Your Honor just made on the record, with one minor addition, which is that the informal discussions we had with Mr. Cooper on behalf of Socotra REIT 1 LLC also resulted in the addition of the word perfection at the end of paragraph 7, but the end of paragraph 7 is just intended to try to make sure that the status quo is maintained, whatever that status quo is, and then that'll be down the road issues to the extent that anyone has an issue with the status quo. But for now, as to the today issues, we're just looking for approval of the sale, and in accordance with the comments you already made and what we already put on the record in the status report. So unless you have any further questions for me, I will defer to Mr. Cooper to see if you have any comments on it as well.
I don't. Thank you, Mr. President. Mr. Cooper, would you like to be heard this afternoon?
Thank you, Your Honor. I don't have anything to add. Our clients are okay with the revised form of order that was filed today.
Okay. Very good. Thank you, counsel. Would anyone else on the phone like to be heard regarding the debtor's motion to approve sale of these two properties? Okay. Well, the court has reviewed the motion, the supporting declarations. The court has no reason to believe that the purchase price is inappropriate and the best that could be realized under the circumstances for these properties. The court notes that the creditors committee supports or at least doesn't oppose the relief being sought, and indeed there were no objections to the relief being sought. So in light of that, the relief sought is appropriate, and the court will grant the motion. The court has reviewed the proposed form of order, most of which is entirely standard and appropriate in this context. There's one minor, I think the most substantive tweak the court, which we'll make in chambers on our end. The cross-reference in finding paragraph F to paragraph K below probably should be to both J and K, since those two together encompass the good faith issue. And that finding also is supported by the record before the court. So unless, Mr. Crosby, you have any issues with changing that to paragraphs J and K, we'll make that change, and then any other minor cleanup changes we have on our end, and get that order entered.
No issues, Your Honor. Thank you.
Okay, very good. All right. So the other matters are just our general status conference, and then I need to provide some additional dates and get a scheduling order entered. Today was our last previously set hearing. Just going through the status conference report, Ms. Gooley, I saw that you changed law firms. Congratulations, always very exciting. I did that once in my career. I suppose we'll see if any issues arise in the context of the debtor's forthcoming application to approve the employment of the O'Melveny firm as co-counsel for the debtors.
For the record, Your Honor, Julian Garuli, thank you, Your Honor, for the kind words. I have moved firms a few times more than once, but it's always an exciting experience. O'Melveny, as Your Honor knows, is a fantastic firm, and we're really looking forward to continuing to keep a great team and a great working relationship we have with all the professionals in this case going forward. And as Your Honor mentioned, we obviously will have an employment application that I know is close to done. I saw a draft even this morning, so I expect that will be filed in the next couple of days. And as always, happy to speak with Mr. Dyer too in his office and let me know how we're viewing this. Thank you.
Okay. Thank you, Mr. Gooley. Again, since none of that's before the court today, I'm not going to comment, but certainly running things, particularly in the context of employment and compensation of professionals by Mr. Dyer's office, is always a good idea, so I certainly would encourage that. Okay. Next, in the status conference report, I saw a general update about the status of the debtors and the creditors committee's ongoing investigations. I've signed several orders authorizing Rule 2004 exams in connection with the investigation. It sounds like things are moving forward, and I'm sure the court and some of the parties in interest look forward to seeing what the status conference report describes as material developments to come in the coming weeks. And I also understand where things are at on the property marketing front. I'm not sure if there's anything else other than housekeeping to address, but Mr. Gooley, if the debtors would like to add or expand on the status conference report, I'd be happy to hear from you.
Well, thank you, Your Honor. Again, for the record, Julian Garuli. Your Honor, given the nature of the case and where we are, our debtor's preference would be to defer discussion of the status of the investigation and next steps for just a short time there. I know there's not much in that status report, but I do think, given where we are, that's appropriate. I do know Mr. Crosby has dates that I think would be helpful for us to have on the calendar from Your Honor for a further status conference and hearing date. And these are dates that we have socialized a bit with some of the other, well, I should say, our friends of the committee. Your Honor, thank you.
Okay. Thank you, Mr. Gooley. We'll circle back to that. Mr. Kornfeld, anything just generally about the case from the committee's perspective today?
Thank you, Your Honor. Jay Kornfeld for the committee. We are working side by side with the debtors on the investigation issues, and as Mr. Gooley said, we have work through some calendar issues that I think Mr. Trazi will talk with the court about. We're in sync with them on those issues and look forward to being in front of the court shortly on some of these other issues. Thank you very much.
Thank you, Ms. Kornfeld. I guess why don't I ask you and Mr. Gould, I know early on, even before there was a committee, your individual ad hoc group and then the committee has emphasized the kind of particular need for speed in this case, which is a need to execute most bankruptcy cases, but I certainly understood the economic realities of this case. So I'm just curious if the parties have started thinking about what a plan might look like or having some early discussions on that front, or if really the investigation needs to be closer to conclusion before those discussions start.
I'll begin first, Your Honor, for the record, Julian Gurley. So we have had some very initial discussions, I would say, among the advisors for the debtors and the committee about a plan. I think Mr. Kornfeld can absolutely speak for himself. I think we collectively, given the nature of these cases and what we have in front of us, thought it would be most productive from a sequencing perspective to get through with some immediate action items on the investigation front, so we had sort of better clarity on what the structure of a plan and what we hope would be obviously a consensual plan would look like. I think we're not there yet in terms of the debtors and the committee negotiating plan terms. If that's Your Honor's question, although I do think that that's obviously something that we engage in, and I think the debtors and I would say the committee hopes that in the next few weeks we'll have better, as I said, visibility from the state's perspective about sort of what the track looks like going forward.
Okay, very good. Thank you, Mr. Cooley. I understand. Mr. Kornfeld, anything you'd like to add on to that?
Oh, Your Honor, the only thing I would add is obviously from a task-oriented and sequencing status, getting the real estate marketed and working to sell it, and really figuring out what the estate had and how to go about it was a meaningful part of what we've all been working on early in the case. The other thing I would say is that the debtors' records were relatively, I don't know if they were disorganized, but they were certainly, in a place where it took a tremendous amount of time, effort, organization, diligencing, and analysis to kind of make sense of them. And so when Mr. Gurley talks about investigation, I think it really did start with understanding what the records were, how they were organized, et cetera, and locating records, some from third parties. Obviously, both the committee and the debtors have been active on the 2004 front, consistent with the investigation discussion. And we have had, I guess what Mr. Gurley has properly characterized as initial conversations about what a plan might look like. I would say that as time has passed, the committee and the debtors, from my perspective and the committee's perspective, appear to be looking at the administration and work in this case very similarly, and I expect that we will come up with a plan down the road that is consistent with that. So at this point, there continues to be a deep commitment to cooperating between the parties. No reason to do otherwise, and for now, we're working hand in glove and look forward to, as Mr. Gurley sort of now piques all of our interest, to be back in front of the court at some point in the near term.
Okay. Thank you, Mr. Kornfeld.
Thank you.
Mr. Dyer, anything high-level comments from the U.S. Trustee's office relating to the case?
Thank you, Your Honor, but no, not presently. I understand where the parties are and how they're working. They have, again, a couple of phone calls with debtors' counsel on questions, and they've kept me apprised. So thank you.
Okay. Thank you, Mr. Dyer. Anyone else on the phone who would like to be heard about anything relating to the case? Okay, Mr. Cosby, why don't we close out the schedule?
Yes, thank you, Your Honor. Cal Crosby again on behalf of the debtors. As you know, Your Honor, I think you noted it at the last hearing, is that the omnibus hearings that were scheduled at the initiation of the case have dried up now, so we don't have any other items on the calendar, any scheduled hearings, I should say. So we've collectively looked at, and collectively meaning the committee and the debtors, and we've looked at least one date per month over the next couple of months that we think would be helpful to have for status conferences or as placeholders to hear motions to the extent anything is filed. And so we're looking at, obviously, subject to the court's availability, we're looking at the week of February 19th and then the week of March 11th, although ideally we're targeting March 12th if possible, Your Honor.
Okay. How about February 22nd at 10:30 for the first date, and then I could do March 12th at 10:30 as well. That should work. And then beyond that, I had April 17th and May 15th for you. So we do February 22nd, March 12th, April 17th, and May 15th each at 10:30 a.m. by phone. I don't need everyone to say yes because we'll be here all day, but I guess are any of those dates and times intensely problematic for anyone? Okay. Okay. Thank you, Mr. Clark. Mr. Kornfeld, do those sound okay? You think I'm
those are fine with us, Your Honor. I'm going to ask Mr. Gurley maybe a question. I think that we had talked about looking for a potential date for a hearing, but I'm not sure if Mr. Gurley's thought on that has changed. So I'll let him address that with the court.
Okay. And I'll just note, just so that record's complete, we do also have on calendar a hearing on Monday, March 4th, relating to the other pending sale motion, the one that had the more elaborate.
Right, that's Sensa. I think it was a Sensa sale, right, Your Honor?
Yeah. So that matter, to the extent a hearing is necessary, we've got that on calendar for March 4th. But Mr. Gurley.
Thank you, Your Honor. Is the March 12th date, Your Honor, is that a status conference and omnibus hearing date, so we could set motions for that date?
Yes, yeah. Anything other than, we won't be at plan confirmation stage. So, yeah. Do you anticipate something where we'll need in-person testimony?
We might need it that day, yes.
Okay. We can. I'll make sure to set that as presumptively in person, and then we can pivot to by phone.
Thank you, John. Okay, Mr. Frankel, thank you.
And the February date, just doing February 22nd, just doing that by phone is okay?
Like telephonic. I think we're anticipating that would be more along the lines of status conference, looking toward March 12th.
Okay. That makes sense. We will get that on calendar. I will get a scheduling order put together and entered. That includes those 4 dates and times and specifies that the March 12th hearing will be in person in Yakima unless subsequently converted on the docket to telephonic. So. All right. Anything further to cover today? Mr. Willie?
No. Thank you, Your
Honor. Ms. Kornfeld?
Nothing from me, Your Honor. Thank you.
Okay. Anyone else on the phone today? All right. Well, thank you, Aaron, very much for your time. We'll get an order entered granting the debtor sale motion and also the scheduling order docketed as well. I hope everyone has a nice rest of the week, and we will speak again in February. We're adjourned.